everyone. My name is Ayush Kumar Singh. I am from FI University, Dehradun, currently pursuing my legal internship from LEXIS and Company. So today we are going to discuss the different types of writ. There are basically five types of writ, but it is important to know that what is a writ. In general meaning, a formal order in written issued under seal in the name of a sovereign government, court, or other authority commanding an officer or other person to whom it is issued is to do or refrain from doing some act specified therein. Under the Indian Constitution, Supreme Court and High Court are the empowered to issue writ for the enforcement of fundamental right. Under Article 32 of Constitution of India, it grants the extensive original jurisdiction to Supreme Court in regard to enforcement of fundamental right. And under Article 26 of Constitution, it has been exercised not only for the enforcement of the fundamental right, but for the purpose of for other purpose for the High Court, and jurisdiction is wider and extend in fundamental right and other constitutional rights for the High Court. Now, there are basically five types of writ: habeas corpus, mandamus, prohibition, certiorari, and quo warranto. Now, what is habeas corpus? Habeas corpus means you have the body. The person, when arrested, can move the court for the issue of habeas corpus. It is an order by the court to the detention of authority to produce the arrested person before it, so that it may examine whether the person has been detained lawfully or otherwise. If the court is convenient that the person is illegally detained, it can issue the order of his release. Now, who can apply the writ of habeas corpus? In generally, uh, that an application can be made by the person who is illegally detained, but in certain cases, an application of habeas corpus can be made by the person on behalf of the prisoner. That is anyone, and that could be anyone, his friend, family, or relatives. Now, the writ of mandamus. Mandamus is a Latin word which means we command. Mandamus is an order from a superior court to the lower court or tribunal or public authority to perform an act which falls within its duty. Simply, it is a writ issued by the public officer to do a thing which is a part of his official duty, but with which he has failed to do it so far. This writ cannot be claimed as a matter of right. Now, the third one is writ of prohibition. Writ of prohibition means forbidding or stopping someone. It is a writ issued by the superior court to the lower court or a tribunal forbidding to perform an act outside its jurisdiction. After the issue of the writ, proceedings in the lower court or etc. comes to an end. Now, the fourth writ is certiorari. Literally, certiorari means to be certified. The word certiorari is issued by the writ of certiorari is issued by the Supreme Court to some inferior courts or tribunals to transfer the matter to it or to some other superior authority for the purpose of consideration. Now, the last on the fifth one is the writ of quo warranto. The word quo warranto means on what authority one is holding the public office. In this writ, this writ is issued with a view to restrain a person from acting in a public office to which he is not entitled. For example, a person of 62 years has been appointed to fill a public office wherein the retirement age is 60 years. Now, appointed appropriate high court has the right to issue a writ of quo warranto against the person and declaration for the office of vacancy. In the case of Bridge versus State of UP, when the holder of an office has been continuing in an office for a long time and there is no complaint against him, the court refused the writ as it would be vaccination. So here's we have discussed all the five types of writs. So thank you, and if you like the video informative, so please like, share, and subscribe. Thank you.